Hey guys, I'm going to try to make this relatively brief, which could really mean anything, because I'm going to be back here in 2 hours with Omar to go over that motion to recuse the judge, and we'll explain that a little bit. But this just came up. It's on a separate docket, so you won't see it on the normal place you're looking. I'll link to it. But I guess Blake Lively has served a subpoena to Justin Baldoni's law firm, seeking certain communications and documents. So we're going to go through that really quick. Let's see. I don't know if you can hear that. There's some really loud fucking crickets outside right now. Not that you needed to know that, but okay. All right. Respondent Blake Lively has served a breathtakingly overbroad subpoena directed to the law firm representing the Wayfair parties in a highly publicized set of litigations arising from Lively's allegations of sexual harassment on the set of the film It Ends With Us. The litigation, pending in the Southern District of New York, has caused a media and internet frenzy fueled mainly by the celebrity status of Lively and her husband, Ryan Reynolds. And you're going to see statements in this document from both the law firm for Justin, and you'll also see Blake's attorneys in here. But right now we're starting with Liner Friedman. So, although the media coverage was initially favorable to Lively, as more facts and evidence emerged, the tables turned and Lively has become the target of a storm of negative media coverage rather than accept responsibility for her own precipitous actions, which sparked the media frenzy. Lively would like to shift blame to the Wayfair parties and their counsel. The overheated media coverage of the Lively-Baldoni dispute is merely a sideshow. Nevertheless, Lively has now served an exceedingly broad subpoena, not on the Wayfair parties, but their counsel, targeting, and this is the law firm LFTC, targeting their contacts and communication with traditional media outlets and digital providers, sources of information allegedly conveyed to the media, and even the firm's financial and telephone records. The individual requests are, on their face, extremely overbroad, sweeping and privileged communications and work product, and reams of information irrelevant or only tangentially relevant to the parties' claims and defenses. Sorry, one sec. Yes, it is. Okay. The subpoena also includes 14 pages of... What the fuck is that word? Hang on. I'm tired. Prefatory? How do you say that? Yeah, prefatory. Okay. 14 pages of prefatory definitions and instructions, 38 complex definitions, exponentially expand the scope of the 8 individual requests. The definitions are not merely vague, but in some cases inscrutable, requiring LFTC to guess as to what is being sought. Right, we're going to skim over some of this. The sheer breadth of the definitions and instructions alone speaks volumes about Lively's real intent, and the most cursory review of the subpoena raises the specter that the subpoena's primary purpose is not to obtain legitimate discovery, but to intimidate and harass the Wayfair parties and their counsel and multiply the proceedings and their costs. Courts disfavor efforts to obtain discovery from opposing counsel and apply 2 tests to determine whether to permit such discovery. So this is kind of some of the stuff that I'm going to skim over because I'm not the best person to explain this. And like I said, I'm going to be back in 2 hours. So, all right. Under either Shelton or Friedman, which is the 2 they were mentioning above, the subpoena should be quashed or drastically modified as it imposes an excessive and undue burden on the litigation, invades the attorney-client and work product privileges, and opens the door to discovery of LFTC's litigation strategy. In fact, Lively's subpoena flies in the face of well-established authority and policy, frowning on the efforts to obtain discovery from opposing counsel and deter such litigation tactics. Okay. So that was the firm's opening statement there. This is Blake's. On December 31st, Ms. Lively initiated litigation in the Southern District of New York, blah, blah, blah. See, she alleges that she and other employees, cast and crew of the film were the subject of unwelcome and inappropriate behavior by Mr. Baldoni and Mr. Heath during production of the film, and that she was retaliated against through a social manipulation campaign by the Wayfair parties for lodging her grievances regarding the conduct of Mr. Baldoni and Mr. Heath on set. One sec. What has she won now? Nobody won anything. Nobody won anything. Don't worry about it. Well, not this second anyways. Hey, Zach. What's up? Sorry, I didn't realize it was your birthday yesterday. Happy birthday, man. All right. Okay. The social manipulation campaign was intended to be, in the Wayfarer Party's own words, untraceable. Since the Lively action began, Ms. Lively has issued substantial discovery to uncover the tracks of this untraceable campaign by identifying and obtaining evidence from the Wayfarer Party's network of agents who have participated or are currently participating in the campaign. Ms. Lively has alleged that Liner, Friedman, Tatelman, and Cooley, the law firm, they're going to call it Liner, is part of this network. Specifically, Ms. Lively alleges that the campaign was carried out in connection with the engagement of Jed Wallace, an individual who specializes in executing confidential and untraceable campaigns across various social media platforms, and his company Street Relations. Ms. Lively alleges that Mr. Wallace and Mr. Friedman of Liner have a very close relationship and began working with the Wayfarer Parties in mid-August 2024 during the initial time period of the alleged smear campaign and months prior to when Ms. Lively brought suit against them. We've seen that text before. Ms. Lively further makes extensive allegations about Liner's role as an agent in the Wayfarer Party's ongoing retaliation campaign and defamatory conduct that have caused the media frenzy and overheated media coverage that Liner claims is self-inflicted. In particular, Ms. Lively alleges that, we've seen all this, so we're good. It was stupid the first time. Legally, I don't know, but personally, I felt it was pretty stupid. All right. As the above shows, Ms. Lively alleges specific involvement by Liner as a percipient witness to an agent for this untraceable and defamatory campaign. The subpoena is the only means by which Ms. Lively can obtain information from a third-party co-conspirator who features heavily in Ms. Lively's complaint for directly participating in and witnessing this untraceable media campaign well before litigation was filed and continuing through the present. Discovery, even as to attorneys, is warranted in these circumstances. Okay. They also want to transfer it to the court that they're in right now, the Southern District of New York. So, like I said, this is a different court, different docket. I'll post a link to it. Okay, we're going to skip over the transfer stuff. Here's what she's asking the law firm to give them. So, who filed this? Blake Lively filed this. The Wayfarer Parties did it's like a joint filing on the motion to quash the subpoena that Blake Lively served on the law firm. So, I saw a video where Shasti Flaw says they won't find anything between her and them. Not thinking like I'm random as fuck, but if anybody wants to see my unanswered requests for comment, I did send some, so whatever. I don't really give a fuck. So here's request for production number 1. Agreements effective at any point from July 1st, 2024 through the present, whether executed prior, on, or subsequent to either date, including contracts, retainer agreements, and engagement letters between or involving you, including on behalf of any Wayfarer defendant, and any content creator concerning the consolidated action, Ms. Lively, Mr. Reynolds, blah, blah, blah. Or with any content creator who has spoken publicly regarding the same. So I guess nobody's going to ask, but if you want to see the email that I sent and did not get a response to, that's fine. All right. This is the law firm's contention. Request number 1 seeks past and present agreements between the broadly defined firm and content creators. And we've seen them argue about the definition of content creators in the other court recently, like last week or something. The firm is counsel for the Wayfarer Parties and has been since the inception of this dispute, when Lively first hurled her public accusations against Justin Baldoni. Courts disfavor discovery directed to opposing counsel over concerns of the burden such discovery places on the adversarial process and the potential of opening a backdoor to obtaining privileged information about an opposing counsel's litigation strategy. Okay. We're going to skim over some of this stuff. Like I said, I'm not the best person to explain this part, so I'm just not going to, since I'm not in a rush, but I'm trying to keep it brief, so. Request number 1 seeks agreements between the firm and content creators through the present. A request for documents from opposing counsel during the litigation potentially implicate multiple privileges, including the attorney-client privilege, attorney work product protection, and the litigation privilege. Okay, definition of digital campaign is equally obtuse and broad. So we're not going to go over all that argument about what means what, because that's going to get boring. Maybe not to me, but to people that are listening to this. So, okay, a lot of this is just going to say it targets potentially privileged information. This principle applies to, whoa, what the fuck was that? Did you guys see that? My screen just did some crazy shit. This principle applies to public relations consultants who assist in the rendition of legal services. Okay. Okay, so this is Lively's contentions at the outset. As Leiner acknowledges, this district is mixed on what standard applies when a party attempts to depose opposing counsel, with some courts applying Friedman. I think it's Friedman. Is it Friedman or Friedman? I don't know. And others applying the more stringent Shelton assessment. And that's, again, stuff we're going to skim over. So, request number 1 seeks a narrow set of documents that are highly relevant and indeed crucial to the Lively action. Specifically, it seeks the production of agreements between Leiner and any content creator concerning certain topics directly related to the Lively action. Whether or not such agreements exist and with whom is relevant to how the Wayfair parties pursued the alleged retaliation campaign since August 2024 through today. Indeed, it would be highly relevant to Ms. Lively's claims if, for example, the Wayfair parties have access to and are able to direct negative messaging through certain content creators' platforms via Leiner. Okay. This possibility is not merely hypothetical. Mr. Friedman's Rolodex of clients has included several influential figures. I mean, Megyn Kelly springs to mind, who have been notably vocal regarding the Lively action. Yeah, and that's true. I've never seen anything like this request before, so I don't know how normal this is. Ms. Lively is entitled to know whether any content creators currently have any agreements to create or influence content or otherwise alter the public narrative regarding her. I mean, I know Brian's been on Megan's show a couple times, but I honestly feel like she would just bag on Blake for free, you know? No agreement necessary. All right. Leiner does not claim that this information is irrelevant and instead argues only that it's not crucial to Ms. Lively's sexual harassment and emotional distress claims. Well, the emotional distress claims are, when was this drafted? Because that was officially dropped with prejudice today. At least the actual negligent infliction and intentional infliction claims. All right. In other words, by Leiner's own concession, this information is relevant to at least Ms. Lively's other claims, including her retaliation and conspiracy claims. That is precisely her point. Second, there's a substantial need to obtain this information from Leiner, as no other means exist to obtain the information. In particular, to the extent such agreement exists, they will be exclusively in the custody, possession, and control of Leiner and a universe of content creators that cannot be identified, let alone comprehensively, except through Leiner. Leiner does not dispute this consideration. Third, Leiner's involvement in connection with this information is not in its role as litigation counsel in the pending litigation. Rather, given that Ms. Lively filed the CRD complaint on December 20th, the work that Leiner performed until that date was exclusively as a witness to the underlying events. Likewise, any work that Leiner performed in deploying or directly retaining content creators to further retaliatory anti-Lively narrative, Jesus Christ. Okay. Since that time would not be, I'm sorry. I'm just thinking about how most of this just stemmed from a video of her being a bitch. This wasn't some great conspiracy. Okay. But instead as an agent involved in the liable conduct. Discovery is warranted in these circumstances. Fourth, such information is not privileged or otherwise protected work product. While Leiner argues that request number 1 targets privileged information in the event that content creators were retained to advance the goals of the litigation, which would be indicative of the retaliation campaign that Ms. Lively alleges, counsel agreements or engagements are not privileged. I mean, it's really weird that all this kind of springboarded off of Shasti's thing, because if you go to your YouTube channel, you can see that she used to post like other interviews with other celebrities, and it just so happened that when Blake's, stuff became relevant again, and she's all grab your fucking florals and nobody likes that, then she's like, oh yeah, by the way, this person was a total bitch to me. Like, it was just a random organic criticism. It wasn't like this is like a pre-planned, whatever. All right. Liner is they're calling it Liner, the law firm that represents Justin Baldoni and Wayfair. Lauren, you don't hate Blake. You're just working for Justin for free. I work for nobody. That's the only reason I do this, because nobody can tell me what to do or say. And I don't hate her. I just think she's a cunt. All right. Mr. Friedman appears to have built his brand on blurring the lines between acting in his capacity as an attorney and serving as a public relations function. Huh. Oh, and there's that Hollywood Reporter article about him. Extensively addressing Mr. Friedman's out-of-the-courtroom approach, quoting Mr. Friedman as stating, if you fuck with my client, you get what you get. I mean, okay. That non-legal spokesman role extends to this case, where Mr. Friedman has prioritized public relations to the point that his inflammatory filings, apparently made to create a press uproar, were recently struck from the record by the issuing court. We all know what that's about. Oh, and they're still mad about the Madison Square Garden comment. Look, I thought that was funny. Was it a good idea to make that comment? No. But it was funny, so I'll overlook it. All right. Look, it was a funny thing to say if you're just like somebody who's passively criticizing. I don't know if, as the lawyer for this guy, you really want to come out and say something like that right now. I don't know, but I won't object to that. Okay. In this scenario, attorney-client and common interest protections could not encompass the content creators as public relations professionals retained by Liner, because they would lack any legal purpose and would not facilitate Liner's legal representation of its clients in the lively action. Okay. Request number 2, they're asking for documents concerning or relating to any invoices for services rendered. So like basically if they paid anybody. We're going to skim over this part. All right, number 3 is, what is number 3? Documents concerning or relating to any payment. Okay, yeah, so payment between or involving you, the firm, including on behalf of any Wayfair defendant and any content creator where such payment is concerning or relating to the consolidated action. Ms. Lively, Mr. Reynolds, blah, blah, blah. Okay. Again, we're going to skim over this part. Number 4, documents sufficient to identify the names of the financial institutions, the names of the account holders, and any account numbers associated with all bank accounts you use to make or receive any payments. Concerning the use of digital, online, content creator, or influencer services, concerning the consolidated action, etc. Okay, number 5. For the time period between July 1st, 2024 through present, all documents and communications involving you, the firm, including on behalf of any Wayfair defendant, concerning digital, online, content creator, or influencer services concerning Ms. Lively, Mr. Reynolds, any of the Wayfair defendants, etc. Okay. So this is Justin's firm's contentions to that one specifically. Request number 5 targets the firm's communications through the present involving the firm and concerning digital, online, content creator, or influencer services. Okay. Request number 5, which incorporates Lively's sweeping definitions of the firm, content creator, and digital campaign, should be quashed on the same overbreadth and grounds as requests 1 through 4. Most importantly, on its face, it targets attorney communications and work product, including the firm's internal communications and communications with third parties protected. Indeed, Lively implicitly admits that the request seeks communications between the firm and its clients by acknowledging that documents responsive to this request may be in the possession, custody, or control of the Wayfarer parties. In other words, the Wayfarer parties have possession, custody, or control of communications with their counsel. Requests which seek privileged communications and insight into opposing counsel's strategy are precisely the reason why courts frown upon and limit discovery requests to opposing counsel. Request number 5 is a blatant effort to invade the defense camp and thus should be quashed. It fails to satisfy the second and third prongs of the Shelton test, and that's something that we're going to skim over because, like I said, I'm not the best person to explain that to you. And these are Blake's contentions to that. I'm just trying to see if there's anything really interesting. There can be no doubt that Liner's participation, if any, in communications regarding content creator and similar services concerning Miss Lively, Mr. Reynolds, any of the Wayfarer defendants, etc., is highly relevant to the Lively action. Liner primarily rests its privilege objection on the claim that the request seeks its internal communications and those with protected third parties, but the request does not seek internal communications or communications among Liner. For the avoidance of doubt, request number 5 seeks external-facing communications. It takes extra precaution to exclude any responsive communications in the custody and control of the Wayfarer parties, such as where Liner, a client, and a content creator are communicating collectively. They collectively ignored my request for comment. Does that count? I'm still salty about that. All right. This is number 6. There's only 8 total, so we're almost done here. All documents and communications between you and any journalist, reporter, producer, editor, or any other representative of a newspaper, online news source, podcast, television network, radio station, or any other form of media. Is that all? Concerning or related to the consolidated action. Miss Lively, Mr. Reynolds, whatever. This is going to be pretty similar. Liner's objections or contentions say it is difficult to conceive of a broader, less particularized discovery request than one sweeping in virtually the entire media. Liner is not required to guess as to who falls into the expansive categories of persons swept into request number 6. The sweeping request also trespasses on the rules disfavoring discovery from opposing counsel. The firm's communications with the media are irrelevant to the key issues, whether Lively was sexually harassed on the set of the film, and whether either side defamed the other. In light of the First Amendment's guarantee of free speech, a smear campaign is not in itself actionable. If the claim is defamation, the issue is whether certain statements by the firm on behalf of the Wayfarer parties were false and malicious. The mere fact that the firm may have communicated with the media is irrelevant. Okay. And these are Blake's contentions. Request number 6 seeks information regarding Miss Lively's retaliation and defamation claims, in addition to the allegations regarding Liner's alleged involvement as an agent in connection with the retaliation campaign. Miss Lively's amended complaint expressly alleges that Mr. Friedman defamed her repeatedly while acting on behalf of certain of the Wayfarer parties. The extent to which Liner has communicated regarding Miss Lively and related subjects to a network of reporters, whether in connection with the planting of a false or misleading narrative or in connection with defamatory assertions, is indisputably relevant to Miss Lively's defamation claims. Okay. Let's move on to 7. All documents and communications reflecting any communication with any source that provided you information relating to or that formed the basis for Mr. Friedman's public statements regarding Miss Lively. This is the firm's contentions. Let's see. Surely Lively understands that as lead counsel for the Wayfarer parties, Mr. Friedman learned about the facts from his own clients. A request for communications between the firm and any source of information imparted to the firm partner Brian Friedman on its face sweeps an attorney-client communications and likely work product. Surely Lively does not seriously believe that such communications are discoverable. Moreover, Request 7 implicates communications protected by the common interest privilege. The common interest / joint defense doctrine expands application of the attorney-client privilege and work product doctrine to communications with third parties in pursuit of a joint strategy in accordance with some form of agreement, whether written or unwritten. Okay. These are Lively's contentions. Request 7 satisfies those principles for the same reasons discussed in 1 through 6. Okay. It relates to Mr. Friedman's sources for multiple, often defamatory statements identified in Ms. Lively's complaint. This information is crucial to her retaliation and defamation claims and, as conceded, exclusively obtainable from Liner. To be clear, the subpoena is not seeking any communications exclusively with the Wayfarer parties, and where such information would be within the possession of the Wayfarer parties, Ms. Lively has sought that information in party discovery. Request 7 seeks information as to any other person who has provided Liner with information to support Mr. Friedman's vehement assertions directly relating to Ms. Lively. And then they're quoting him here, which is, okay. Blake and her legal team have just one heinous pivot left, and it's to double down on the revoltingly false sexual allegations against Mr. Baldoni. I mean, I have a hard time taking issue with that statement because it's just true. All right. We will not only continue to defend our client against Blake's power, privilege, and all-out lies, but we will now fight even harder for the voiceless in the DB community who are unfairly suffering while she continues to push on her own self-serving and selfish vendetta in the media. Again, I don't really... Legally, I can't speak on this, but personally, I appreciate that statement given the context of everything that was going on at the time, which is this lady taking a tour of fucking public appearances and claiming she's some sort of civil rights champion. All right. Now we'll move past that. All right, this is the last one. All documents, including mobile phone billing records, sufficient to show the calls you or Mr. Friedman made and or received with any source concerning information relating to or that formed the basis for Mr. Friedman's public statements regarding Miss Lively. I think you guys can figure that one out. So. Phone records would be, or have little, if any, relevance, and certainly are not crucial to Lively's claims. Let's see. Yeah, there's nothing I really want to look over there. I don't know if anything else that I put in here is actually like something I want to go over right now, but yeah, I'm not gonna, because this is all like definitions and shit. 4chan. Okay. You guys posted on 4chan? Listen to me say that. 4chan. Like a redneck. Yeah, I'm not gonna do all this. So this was an email. Okay, and I think it's to Gottlieb. They're requesting a telephonic conference within 10 days of delivery of the letter, okay, regarding the subpoena. The subpoena seeks reams of information that bears no or at best tangential relevance to the parties' respective claims, counterclaims, and defenses. Not only is the subpoena overbroad, it targets information protected by the attorney-client privilege and attorney work product doctrine. Among other things, Lively seeks identification of the firm's financial accounts, including the financial institutions at which the accounts are maintained and its account numbers. The subpoena fails to narrowly tailor its requests, seeking extremely broad categories of irrelevant or privileged documents. Okay. The time frame for certain requests is well outside the time in which the alleged smear campaign occurred, defeating any argument that the requests are tailored to elicit information relevant to the alleged smear campaign. Simply put, the sheer breadth of the definitions and instructions alone speaks volumes about the real intent: to intimidate and harass opposing counsel and multiply the proceedings and their costs. Okay. I think that's all we really need to get through right now. Okay. So I'm gonna finish this up here. When I close this out, it's gonna take you to the link for the next stream, but it's not gonna start till 10:30 Eastern, so that'll be about an hour and a half. And I'll be with Omar to talk about there was a motion for recusal. It's not actually on the docket yet. The guy who filed it, he's done a couple of things, and he puts them out there, after he files them, and he doesn't wait for them to like hit the actual docket, so you won't see it if you go look for it. But we do have it, so we'll go over that and see, and we'll just talk generally about people saying that the judge needs to recuse himself and what that means and what would warrant that. And then I sent him a link to Cassidy's thing, and so hopefully we'll get time to go over that. But remember that it is very late at night for me when we start, because it's 3 hours behind for him. So we'll get through as much as we can. All right. Cassidy's live right now. Oh, okay, cool. That's cool. I'll have to listen to her while I'm folding my laundry and shit, because I got to do that now before I start the next one. And only Usli, thank you for the 10, or we just don't like her because of her great personality. I mean, I no arguments here. All right. Thanks, everybody. I appreciate it. And I will see you.